Well, this is it, folks. Last week before the holidays begin. Not sure why we worked so hard to get the government open. Everyone knows nothing's going to happen until we see Trump do his YMCA dance to Auld Lang Syne. Happy Monday, everybody. I'm Brino, and this is the morning report on the federal courts for November 17th, 2025. Do me a favor. Double tap your screen, comment your favorite way to politely tell your boss, yeah, I'll get to that in January, and watch the first minute now, even if you're coming back, so we hit the FYP. Thank you, CompuBear, Chris, and Edward for hitting my wish list. If you'd like to help support my work, keep this sustainable, there is a link in my bio. Now, there's a Supreme Court dissent that came out this morning, so I'm pushing that for later because I want to do a little more research, but I also don't think it's pressing time-wise. For now, let's catch up on what we've missed since last week. We're going to start with an AFL CIO v. Trump case, and this one's about Voice of America, but there's a lot of cases with this same name, AFL CIO v. Trump. And in today's case, the judge is going to tell us one of the reasons that keeps happening. See, back when Trump took office, Donald Trump tried to fire a lot of people and shut down a lot of departments. But for reasons I've explained to you several times, he can't just do that. And so he's been trying to find ways around the system that intentionally makes it difficult to do that, but he's also apparently been trying to sort of punish people who are slowing down his agenda. And that's not just me talking here. The judge in this case actually recognized the moves we're going to talk about here were retaliatory, but we'll get to that in a second. The problem that the administration seems to have run into here, not just the law, but a lack of creativity, which is part of the reason these case names are getting so repetitive. Because not only is the administration trying to circumvent legal protections for workers and agencies, but they're doing so in the same way over and over again. So frequently, in fact, that this judge is now dealing with multiple cases with the exact same facts and arguments. Even the same plaintiff, the employee union, just representing different departments, which is why we keep seeing AFL-CIO v. Trump. It's the federal employees unions on behalf of this agency's employees v. Trump, and federal employee unions on behalf of that agency employees v. Trump, and so forth. And it's easier to say, well, this department should be treated a little bit differently because of some special reason that only applies to this department when you're not using that same argument for every department. But what are the odds that a judge in one case is going to have time to read your filings in another case? Unless, of course, they're both in front of the same judge. So, the administration says that the government employees in certain special departments shouldn't be allowed to unionize. Or be allowed to get into collective bargaining, to negotiate as a group, because this particular department is key to our national defense. And so if the employees were to, say, go on a strike, that would put the United States at risk. Now, there are a couple of weaknesses to this argument. First, since the administration is trying to shut down these departments in other ongoing litigation, it's hard to argue that we can't survive without them. Again, I think they were just hoping the judge wouldn't notice the other cases. More importantly, though, the administration has now tried to revoke collective bargaining for about 2/3 of government employees. So it's kind of hard to say that 2/3 of our employees are so essential that their rights of association should be infringed. And that argument gets even tougher when you try to say that, sure, we did try to do this to almost all employees, but these employees are in a special group. They have to be separated off. But then you use that same argument in multiple cases in front of the same judge. Oof. So, the judge said, I've already responded to this exact same argument in several other cases, and the answer is no. And the judge pointed out that the other cases were part of the reason he was doing this. You can't find a special exception in every circumstance. That's not how exceptions work. He also said that this executive order was issued in August, right after the courts had stopped the administration from dismantling the agencies in this case, like Voice of America, and that order was clearly retaliation for that. So there is a preliminary injunction here. I'm sure the administration will appeal it. They always do, but so far Voice of America has managed to withstand the administration's attempt to dismantle it, so we'll see how those efforts go. Now, I'm going to step into a state case for a minute because this one may have some legs. On Friday, an administrative order was quietly filed in the Superior Court of Fulton County, Georgia, appointing Peter Skandalakis to act as District Attorney Pro Temp for the Atlanta Judicial Circuit to prosecute the case of State of Georgia v. Donald J. Trump, the last of the criminal indictments against Donald Trump and his associates for election tampering in 2020. Now, all of this occurred because the prior prosecutor on the case was removed by the Court of Appeals after the finding of the appearance of impropriety. Remember when that was a thing? And without a prosecutor, Georgia had to decide whether to allow the case to be closed or to appoint a new prosecutor. and the deadline was this past Friday. And apparently, they asked several prosecutors and nobody wanted that kind of heat. And nobody even called me. I can prosecute, what the hell? So Peter Skandelakis, who is executive director of the Prosecuting Attorneys Council of Georgia, decided to take on this case himself. So he's been appointed to prosecute this. He was DA for the Coweta Judicial Circuit for 33 years. I'd imagine he probably knows his stuff. Plus, his name is really hard to pronounce, so we'll get to see Fox News trip over that for a while. That should be fun. Trump is charged with a number of felonies in this case, including the charge that he told Georgia election officials that they needed to find a certain number of votes. So he's charged with racketeering and solicitation of violation of oath by a public officer, conspiracy to commit forgery, all kinds of stuff. So some really nice felonies he can put on his mantle next to the others. Now, to be clear, these are not immune from prosecution, at least not currently, as they are outside of the work of the president. This is campaign work, so presidential immunity should not apply to these. But then again, who knows? Things change. I'm sure he will try. Okay. Last case is a bit confusing, but it's an important one, and I don't think it's being explained very well. This is what's happening in Chicago right now with the 600 plus detained people who are being released. And this is totally unrelated to any of the other cases we've been talking about in Chicago. So this case, Nava v. Department of Homeland Security, was actually opened in 2018 when the last Trump administration embarked on Operation Keep Safe. This was a 2018 federal blitz on the city of Chicago where ICE agents ran rampant and appear to have violated the constitutional rights of Chicago residents. How on earth could we have predicted our current situation? And plaintiffs sued the administration for violation of several things, including their Fourth Amendment rights, and the Trump administration, tell me if you've heard this one before, filed a motion to dismiss for lack of standing, lack of jurisdiction, and failure to state a claim. I know, it's like a whole different timeline. So in 2020, the court rejected the Trump administration's motion to dismiss, finding at least enough validity to the plaintiff's claim that ICE was issuing warrantless arrests without individualized suspicion to allow the case to proceed on the merits. But for whatever reason, the administration did not want to go forward with the case. Remember, Barrett wasn't on the court yet, Ginsburg was still there. They didn't really want to go to SCOTUS with this at the time. And so Department of Homeland Security agreed to enter into a settlement with the plaintiffs. Now, that settlement took forever to negotiate, so it didn't get signed until Biden was in office. So I would bet ducks to donuts that some news agencies will broadcast this as a Biden-era settlement. But let's be clear, it was initially negotiated under Trump. And the deal ICE entered into required a new policy that actually defined when someone could be arrested and when a vehicle could be stopped. It required this policy to be taught to all ICE agents, and then, just from the Chicago field office, it required regular reports of all warrantless arrests for civil violations of U.S. immigration laws, not criminal. And this agreement was in place for 3 years, from May of 2022 to May of 2025. But in January of 2025, the plaintiffs say that the second Trump administration was right back to its old tricks, so they came back to the court. It took a little while to get back to the top of the court, but eventually the court started requiring those reports again, which had dried up at some point. And there was a big order that came out on October 7th. And a lot of things in this case are broken up sort of to before October 7th and after October 7th. And the judge has gotten a few regular reports by now and had time to evaluate them, so he's made some decisions. First, the plaintiffs asked that the agreement be extended by 3 years. Otherwise, it would have ended this past May. And the judge said no. But for now, he did extend it to February of 2026. Second, the plaintiff said that all of the people being detained need to be released, and the judge broke all those people into pre-October 7th and post-October 7th just because they were in different reports. So since October 7th, assuming that I understood this right, because it's a little bit confusing, 46 people have been arrested without warrants and no criminal violations. 13 of those people remain in the United States. The rest have been removed already. Having evaluated all 13 of these people, the judge ordered that all of them be released without bond by noon this past Friday. I will add that I read that in the judge's order, but the news reports all say that the judge will actually rule on releasing people this week. So maybe he said something different in court. I don't know. My guess is that the news only focused on this next group, which I'll get to here. So third, there are about 615 other people who have been arrested without warrants or criminal charges. And these are all the kind of pre-October 7th people. Many of these people are still being held, and according to the agreement, they should be allowed out on bond unless they are subject to mandatory detention. And the government argues that everyone is subject to mandatory detention. Now, I don't want to get lost in the weeds here. I'm going to skip the breakdown of sections 1225 and 1226, which is the core of the argument here. I'm just going to say there is a big difference of opinion as to whether all 615 of these people are subject to mandatory detention. But according to the judge, when this agreement was reached, there was not a difference of opinion in what that meant. The statute cited by the government requiring detention would not have been read that way, and the judge says the two sides would not have agreed to these terms if that were the reading of the law. And the judge cites his own involvement in that negotiation as authority for knowing what was discussed. So basically, that wasn't the agreement. So by Friday at noon, the judge ordered the government to identify all of those 615 people, let him know whether any of them are actually a danger to the public, and he will rule this week on their release with a $1,500 bond. So that's what's going on in Chicago. I don't know if those other 13 people have already been released or not. I'm sure we'll get an order soon, and I will let you know. All right, that is your Monday morning report on the past weekend in federal courts. Check out the link in my bio to help me stay sustainable, or follow me on the other socials. Otherwise, keep watching, everybody, and I will keep going. Thanks a lot. Have a great Monday.